International Fair Trial Day. Before I start, I just want to point out that on your screen in the bottom, you see a sign interpretation. If you need interpretation from English to Turkish or from Turkish to English, you could go to this button and you can find, you can just press English or Turkish and have a translation. So first, I would like to introduce to you the steering group who organized today's event and the International Fair Trial Day. The participants in the steering group are the Council of Bars and Law Societies of Europe, the European Association of Lawyers for Democracy and World Human Rights, the European Bars Federation, the European Democratic Lawyers, the French National Bar Council, the International Association of Democratic Lawyers, the International Association of Lawyers, the International Bar Association's Human Rights Institute, the Italian National Bar Council, the Law Society of England and Wales, and lawyers Ayşe Bingöl-Demir and Serife Ceren Uysal from Turkey. My name is Irma van den Berg. I'm the president of Lawyers for Lawyers, also an organization part of the steering group. On behalf of the steering group, I would like to thank you all for attending this event on this special day that we feel is very necessary and very urgent. And on behalf of the steering group, I have the honor to shortly introduce the event, explain why we decided to organize it, and introduce our first esteemed speakers. The importance of the right to a fair trial cannot be overstated. This right ensures that everyone has access to a fair and public hearing within a reasonable amount of time by a competent, independent, and impartial judiciary. This right ensures that anyone who is accused of a crime is presumed innocent until proven guilty. This right ensures that anyone who is prosecuted for a criminal offense has all guarantees necessary for a proper defense, including the right to consult and be defended by a lawyer of his or her own choosing. This right ensures that anyone whose human rights and fundamental freedoms are violated can seek adequate and effective protection. This right, the right to a fair trial, is an essential part of a fair and just society and of the rule of law. Without it, miscarriages of justice are unavoidable, and governments and others who violate citizens' rights cannot be held accountable. Unfortunately, as we all know, the rule of law and fundamental rights and freedoms, including the right to a fair trial, are under serious attack all over the globe. In fact, the World Justice Project Rule of Law Index 2020 shows that for the third year in a row, more countries declined than improved in their overall rule of law performance. Governmental oppression and practices undermining international human rights obligations are widespread. As a consequence, in many countries, those who draw attention to and criticize these practices are under constant pressure from governments, prosecutors, and police, and of a judiciary that is not independent and impartial. Journalists, opposition politicians, academics, lawyers, and many others all over the world are being judicially harassed, prosecuted, and convicted following seriously flawed criminal cases that do not meet the standards of fair trial. Of course, this is not a new issue. So why did we decide to organize the International Fair Trial Day now? There is a specific reason for that. The organizations that are part of the steering group have all been involved in observing trials against lawyers in Turkey for years now. We have seen how many human rights violations in Turkey are widespread and systemic, and how unfair the judicial system is for lawyers, but also for many, many others. In 2019, 18 lawyers were convicted to long prison sentences between 3 and 18 years, following a profoundly unfair trial. Among those lawyers were Ebru Timtik and Aytaç Ünsal. They started a hunger strike in January 2020 in response to the serious failure of the judicial system in Turkey and the infringements on the right to a fair trial. They called on the Turkish government to comply with its obligations to secure and to respect the right to a fair trial, not just for themselves, but for all who suffer from being subjected to arbitrary investigations, trials, arrests, detentions, and wrongful convictions. Sadly, Ebru Timtik lost her life on 27th of August 2020. Aytaç Ünsal was temporarily released, but was returned to prison on the 10th of December 2020. During the intense summer of 2020, the idea for the International Fair Trial Day emerged. Instigated by Çiğren Ünsal and Ayşe Bingöl, the steering group was formed, and the first International Fair Trial Day was prepared. The aim of this day is to advocate for the re-establishment of the right to a fair trial in those countries where this right is under serious threat. The International Fair Trial Day will be held every year on the 14th of June. And every year the focus will be on a different country, which will give the international community a chance to draw attention to specific fair trial issues in this country. Given the background of the establishment of this day, but also given the serious and still deteriorating human rights situation in Turkey, the country we will focus on this year is Turkey. Also, the steering group established the Ebru Timtik Award in honor of Ebru Timtik, a fierce and courageous advocate for the right to a fair trial during her whole life, for her clients, for her colleagues, for all victims of human rights violations arising out of a lack of respect for fair trial principles. With this award, every year we want to honor such an advocate or an organization fighting for the right to a fair trial in the focus country of that year. People like Ebru Timtik and all others fighting to protect the right to a fair trial, sometimes in dire circumstances, are a great inspiration to us, the members of the steering group, and undoubtedly to many others. And hopefully they are also an inspiration for the citizens and the human rights defenders of the focus country of a specific year. Although the International Fair Trial Day was established by lawyers and lawyers' organizations, the International Fair Trial Day is for everyone affected by fair trial issues. As you will see in the event of this afternoon, the situation in Turkey of journalists and of civil society in general will be discussed as well. And next year and the years after, we hope to include other organizations than lawyers' organization in the organization of the next International Fair Trial Days. This brings me to the program of today that consists of two sessions. First, our keynote speaker, Mr. Diego Garcia Sayan, will deliver the keynote speech. After that, there will be a panel discussion moderated by prominent journalist Banu Güven. And then there will be a 10-minute break, after which the second session will start, the Ebru Timtik Award ceremony. But right now, I would like to introduce to you Mr. Diego Garcia Sayan. He is the UN Special Rapporteur on the independence of judges and lawyers. Mr. Garcia Sayan served as a judge in the Inter-American Court of Human Rights from 2008 to 2013. He worked in different capacities for the United Nations and for the Organization of American States, and he was Minister of Justice and Minister of Foreign Affairs in Peru. In 2016, he was appointed as the Special Rapporteur on the independence of judges and lawyers. We are very honored that he is here to take part in this event and to present the keynote speech. Mr. Garcia Sayan, I give the floor to you.
Thank you, Ms. Van der Berg. It's really a pleasure to be with all of you today. Good afternoon for all of you. I am in the morning still here back in Peru. And so to begin, I really want to say that I sincerely congratulate the steering group formed by your very vital and crucial organizations in the defense of rule of law, judicial independence, and the function of lawyers. I have been privileged to be able to interact permanently in the defense of the independence of judges and the role of lawyers with most of your organizations, which play a fundamental role in confronting violations of that principles and rights, and affirming those fundamental principles in the face of the attacks that suffer in various countries, not only in Turkey, as has been recalled some minutes ago by Irma Vandenberg. My special appreciation and thanks for inviting me to participate today, and in particular, my congratulations above all for the initiative to organize the International Fair Trade Day. To defend fair trial standards is to defend crucial components of a democratic society in which judicial independence, respect for the rules of due process, and access to justice must be respected, promoted, and protected. And because they are values and principles that are part of the international standards and norms as substantive reference, the call for an active role of the international community to guarantee them is crucial. As recalled in the text of the call for this meeting, we are holding today the serious failure of the judicial system in Turkey to protect and respect fair trial principles has meant not only the systematic affectation of the function of lawyers, but also of the freedom, physical integrity, and life of many of them. The case of Ebru Timtik and Aytaç Unşal has the tremendous symbolism of having expressed with their hunger strike and protest the feelings of many lawyers and broad sectors of society that do not understand or share the argument, or rather the pretext, that in the name of supposed war against terrorism, the fundamental rights of the population, including the right to have access to justice and to appropriate means of legal defense, can be cancelled. As a special rapporteur, I have been following the evolution of events in Turkey, and in the specific case of Ebru Timtik and Aytaç Unşal, of course, among them. In response to the seriousness of the evolution of events, I have requested at that time an invitation to the government of Turkey to carry out an official visit to the country, so to gather more information from various sources and to dialogue not only with lawyers, bar associations, and human rights organizations, but of course, also with the authorities. Despite this request, I have not yet received the corresponding invitation, an indispensable required for a UN rapporteur to carry out an official visit. In a difficult context for Turkey and several other countries, a meeting such as this one taking place today and the great initiative to establish the International Fair Trial Day play a very important role to share more and better information, and in particular to reaffirm fundamental principles that have to do not only with the rights of lawyers and the role of the legal profession, but with the rights of the population in general. You can count on the vital and permanent commitment of this rapporteur to the projects and activities you promote. For its consistent pattern, extension in time, and number of judges and lawyers affected, what is happening in Turkey, especially since 2016, is an iconic example of what can be described as consistent pattern of demolition of judicial independence and the rule of law. As in other countries, the pretext of a war against drugs is being used to persecute and kill judges and lawyers. It is in the name of war against terror that the repressive arm of the state and government are being systematically used. Combine the anti-terror legislation with vague definitions in the Turkish criminal code and biased interpretations made by certain judges and prosecutors allows the criminalizations of harmless acts and even the exercise of fundamental rights, as is very proper mentioned in your report. Establishing the Ebru Timtik Award is a very important way to pay tribute to her as someone who gave her life to defend certain principles. Her tragic death, as it has been recalled, on August last year, after 238 days into a hunger strike demanding a fair trial year, has been a dramatic denounce of demolition rule of law and of fair trial, affecting dozens of lawyers and to prevent the death of other lawyers. In the presentations that will follow in the fantastic panel that you have organized, you are going to have ample opportunity to analyze with detail the major challenges being faced now in Turkey. Let me share now with you, as an introduction, a general view of some of the major challenges being faced in different critical situations in countries by lawyers individually and by their bar associations. 4 major challenges are especially relevant. First, the independence of the judiciary and consistent respect for the legal profession as fundamental pillars of a democratic society. Such independence is not provided for the benefit or protection of judges or lawyers as such, nor is it intended to shield them from being held accountable in the performance of their professional duties and to the general law. Instead, its purpose is the protection of the people, affording them an independent and effective legal profession as the bulwark of a free and democratic society. Second, government and control of the judiciary can make the legal profession less willing to challenge the government or undertake controversial or sensitive cases that may not sit well with the current political institution. Public attacks by political figures against the judiciary, as well as the threat of judicial persecution or intimidation, can further undermine judicial independence, in turn undermining the lawyer's ability or willingness to undertake certain cases or represent certain clients. Third, rights of bar associations, crucial organizations for rule of law and rights of lawyers, are fundamental in these endeavors. Taking into consideration a challenging context against bar associations in different parts of the world, 2 years ago, they were precisely the subject of my report to the General Assembly of the United Nations. I highlighted then the vital role of bar associations and the indispensability of their independence vis-à-vis the government and public and private institutions, and emphasized their self-governing nature and their priority mandate to protect the independence of the legal profession. Fourth, the pandemic is placing dramatic challenges in access to justice in different parts of the world, and the functioning of the legal profession, states of emergency, lockdowns, institutional intrusion of the executives in the judiciaries in some countries, and leading in different places to the virtual paralysis of judiciaries. It won't be easy for justice systems to deal with the increased conflict, which already before the pandemic had 1.5 billion people unable to resolve their justice problems. To conclude, dear friends, I want to commend you that as Special Rapporteur, I have been following in the daily fulfillment of my mandate that attacks on the legal profession in Turkey and several other countries, which unfortunately remain persistent in different parts of the world. I would like to emphasize here the extraordinary contribution of organizations like yours in closely monitoring this situation and documenting the cases that occur. In many cases, in countries that I have been also monitoring or visiting at the global scope that corresponds to my role as a Special Rapporteur of the UN. The steps taken today with the Embro Timchik Award and establishing the International Fair Trial Day is a very important step forward. Congratulations and thanks again for your generous invitation, made me to be with all of you today. Thank you very much.
Thank you very much, Mr. Diego Garcia Sayan, for this powerful speech and for the overview of the most important issues that no doubt will be discussed in the panel discussion that's now coming up. And thank you very much also for the congratulations. So now we go to the panel discussion that will be moderated by prominent journalist Banu Güven. Since 1992, she worked in Turkey for newspaper Milliyet Daily and for news channels NTV and IMC TV. In 2011, she was fired from NTV after she tried to host one of the most prominent figures of Kurdish politics in her talk show. And in October 2016, IMC TV was closed under the emergency rule. So Mrs. Güven experienced firsthand what happens if the rule of law is not respected. Mrs. Güven lives in Germany since 2019 and now is contributing to various media. And also she recently started on her own YouTube channel. I'm quite sure I did not quite do justice to everything Mrs. Güven does, but this is a short overview. Mrs. Güven, I would like to give the floor to you.
Thank you very much, Mrs. van der Berg and Mr. Garcia Sayan. Thank you very much for your key speech. So I'll start again, maybe. Thank you very much, Mrs. van der Berg, and thank you very much, Mr. Garcia Sayan, for your the keynote speech. Well, I'd like to start telling everyone maybe what happened to me a couple of days ago. As I was doing some research on trial, on a case on the web, I came across an interview I had made with Ebru Timtik in 2015, I believe, or maybe beginning of 16. And it was really painful to watch us again talking about the importance of fair trial. She was representing a family, the family of a very young boy who was severely wounded in 2013 by a gas canister shot by the police during Gezi events. And then this boy died. And since then, the lawyers are still, and the family is still fighting for reaching a result, what should be reached through a fair trial. And then today there is one of the most important trials going on in Turkey. This is the mine disaster, we call it. 301 miners were killed years ago, and their lawyer was Selçuk Kozağaçlı from People's Law Office. And today, no one from those who are being tried in this trial are in prison, but the lawyer of the families, Selçuk Kozağaçlı. Again, today is the anniversary of the worst train accident, which wasn't an accident actually in Turkey, and the families are still looking for their chances for a fair trial, but they are being tried. So this is one of the other, these are examples, you know. I mean, we keep talking about the same issues endlessly because of the lack of fair trial in Turkey. And as I said at the beginning, because we had so many conversations with Ebru Timtik about these issues, it means a lot to me to be here today and the first fair trial day together with you. Thank you for making me a part of it. So I am a journalist, and today I am going to host some very distinguished guests. I will start with introducing them. I think someone will join us later. Oh, okay, there she is. So first we have Emma Sinclair Webb. Actually, Emma has been around for a very long time, and she is the assistant director with Human Rights Watch's Europe and Asia division, and she's been the witness of many trials in Turkey since 2007, I guess, or I don't know. I'm right. And so we are going to talk about the situation, the consequences of lack of fair trial on civil society. And then we have Mr. Patrick Henry. Mr. Patrick Henry is currently the president of Avocats Sans Frontières, but he was previously the chair of the CCBE Human Rights Committee for 6 years, from 2013 until 2019. And then we have Sarah Clark. She is head of Europe and Central Asia with Article 19. And before that, she's been working in the legal division of PEN International, and she's been actually also witness to many trials in Turkey, in other countries, and had the chance to talk to the authorities on international organizations, and also in Turkey, in respective countries. So we are going to talk about the consequences for the media in Turkey in particular, And with Mr. Patrick Henry, I forgot to tell, of course, we are going to talk about what the purge we've been witnessing for the last 5 years has caused in Turkey. So I would like to start with you, Emma. Maybe we should start, you could draw us a general picture, an up-to-date picture about what this lack of rule of law and fair trial has meant for the civil society in Turkey in the last couple of years. Where are we now? What is the situation? There are so many trials going on, but we'll also get more specific later. But first, a general picture.
Thank you, Banu, and thank you very much to the organisers for having me speak at this panel, which I appreciate very much. The issue of fair trial runs through everything we do, and where fair trial starts or unfair trial starts is from the very moment that an investigation begins or a detention starts in Turkey, because we see an atmosphere of flagrant abuse of human rights in which detention and prosecution is used as a tool against any perceived government critic or perceived enemy. And that ranges from opposition politicians to lawyers, to civil society journalists, trade unionists, and to thousands and thousands of ordinary people whose names we will never know and who do not fit any particular category as far as professional group. But Turkey has a problem at the moment of having tens of thousands of people held in prison on terrorism laws. And among this, we have the systematic crackdown on civil society, a very chilling, intimidating atmosphere for civil society, best summed up, and I think we'll return to his case later, by the very prolonged imprisonment of Osman Kavala, a philanthropist, businessman, and civic leader, if you like. But it's not only holding people in prison that has had the chilling effect on civil society. We've also seen the introduction of recently a law that imposes much stricter ability for the government to monitor and crack down on civil society, even to the extent of removing people from civic organizations on rather in an arbitrary way, by claiming that they've basically had links to terrorist organizations. We can return to that law too. But basically, the very chilling environment means that it's been off-putting for people in Turkey to get very involved in human rights groups, because they've seen over the past 5 years especially that organizations can very easily get targeted or closed down. Perhaps the first big trial we saw of human rights defenders in the past few years was the trial of people from Amnesty International, but also other local groups. And they were all detained while having a human rights education training on Büyükada, an island just off Istanbul. And that trial went on, and then one of the chair of Amnesty International at that time, the Amnesty's Turkey branch, spent over a year in jail. I think that really had a chilling effect on the whole of civil society. And we then heard that people were very aware that they were under investigation, non-concluded investigations. We also had speeches from politicians against civil society doing reporting of human rights abuses, particularly in 2016 in the Kurdish region. President Erdogan made a speech saying to NGOs, why do you investigate what's going on in the southeast? What is your role in writing reports and monitoring the situation? And that also turned into an investigation against several groups. So it's a very, to sum it up, I mean, there's an intimidating atmosphere, but at the same time, there is still in Turkey, I believe, a vibrant civil society that's quite defiant. And I'm talking here at civil society, I'm including lawyers groups, bar associations as well, and trade unions, because it's, you know, these all play a role in the protection of human rights and in basically not just fair trial, but in broadly monitoring and defending rights in the country.
Thank you, Emma. We will certainly talk about some trials. As you mentioned, Osman Kavala is one of the cases, and also Selahattin Demirtaş's case was also brought up. We are going to talk about these issues as well, because the Turkish, well, judiciary, which is, we can say, controlled by politics, doesn't implement the judgments of the European Court of Human Rights, and there are some consequences. There will be maybe some consequences. But how did we end up here? So this is a question I'm going to ask Patrick Henry, because, okay, we had problems a decade ago in judiciary regarding rule of law and fair trial, but then after 2016, things got worse. The state of emergency made things worse. So there were lots of lawyers who were trained by the European, I mean, like there were joint trainings. I mean, a lot had been made, although there was still problems regarding fair trial, but still everything has changed. So what happened, Patrick Henry, with the state of emergency in Turkey, and how did we end up here? Could you please turn your mic on, or I can do it for you, maybe? I don't know. Yeah, you can. Yeah, you're on. Please go ahead.
Thank you, Manu. First of all, I want to say I am very proud to be here to deal with that important event dedicated to the memory of Ebru Timtik, who fought for justice till she died. In my opinion, Turkey suffered first of all from the bad use of the state of emergency. I explain myself in some points. First, with regard to Article 15 EC-R, it can be admitted that the attempt coup of July 15 justified the use of the state of emergency, as well as, for example, the terrorist attacks that Belgium and France have experienced at that time. But second, the state of emergency does not justify just any measures. It must meet certain principles or conditions. No derogation from certain fundamental principles, abolition of the death penalty, prohibition of torture or inhuman or degrading treatment, no punishment without law, no double punishment for the same offense, and so on. The state of emergency must be limited in time. Here it lasted 2 years, from July 16 to July 18. The measure must be proportionate to the aim pursued to save the state against the perils that threaten it. The measure must be limited in time. They cannot be discriminatory, and so on. Third, in this case, the government has been allowed to govern alone, without the control of Parliament or the Constitutional Court. Four, many of the measures taken have definitive rather than temporary effects. Tens of thousands of public servants, including thousands of judges, were removed from office, not suspended. Their properties were confiscated, not placed under temporary government control. The measures were collective, not individualized. 5. In the judicial sphere, For instance, preventive detention was extended to 30 days without judicial review. Arrests and detentions were permitted on the basis of reasonable suspicion with limited access to lawyers. 6. Judges who were removed from office were replaced by others in a process that did not ensure their independence. 7. The rights of the defense have been considerably restricted, including significant breaches of professional secrecy. I will stop here so as not be too long. I insist on the fact that these decisions justified by the state of emergency are, in most cases, final and have not been reported, at least most of them. So an outside witness can therefore conclude that these measures have allowed a considerable strengthening of the powers of the government and its president, out of all proportion to the threat that had to be averted, and that they have allowed the establishment of an extremely strong mechanism for the repression of minorities, especially women, Kurds, Alevis. All this contributes to the establishment of what we now call in French, démocrature. I mean, democratorships.
Thank you very much. Thank you very much, Patrick. The things you were telling now reminded me of a situation we're witnessing now, where, for example, a TV channel like IMC TV, where I used to work, was closed by a decree some 5 years ago, almost 5 years ago, 4.5 years ago, or not by a decree, but as a result of a decree, I would say. And then years later, just to avoid a further decision in Strasbourg, the Constitutional Court today says it was against the law. It was not lawful to close down this TV channel. So today we are seeing some maneuvers made in some fields, you know, like media and so on, and some people are being released finally, also journalists and so on, but mostly nothing. I mean, these unfair decisions, judgments, they have changed our lives, and they've put so many people behind the bars, and many of them are still behind the bars. So although, now I'm coming to you, dear Sarah Clark, although there are some people, some journalists who have been released recently and so on, the situation hasn't got any better, I would say. Would you agree, or what would you say?
I would agree. I think the situation has become more complex rather than that it's improved. So, you know, in the first wave of repression of journalists and media outlets after the imposition of the state of emergency, we saw the mass closure of media outlets, the mass dismissals without an adequate right of appeal of something around 10,000 media workers. And of course, we had the huge number of detentions of journalists, which gave Turkey the moniker of the biggest jail for journalists in the world. And as you mentioned, you know, many of those journalists are in detention, though we have seen rather a number of releases in the last couple of years. And you know, I suppose what's important to bear in mind is the lack of a fair trial that those journalists were given and continue to be given. At Article 19, along with the Bar Human Rights Committee, we monitored in person many of those trials, and those trials really were emblematic of the lack of a fair trial in Turkey, you know, when it comes to the role of the judiciary, its independence, its relationship with the prosecution, the lack of sufficient access to defense lawyers that we saw for journalists in pretrial detention, the lack of pretrial disclosure, the lack of sufficient evidence to establish even a prima facie case to warrant continued detention or prosecutions. And we saw prosecutions like that of Usman Kavala, like that of the Altons, which were characterized as show trials. Now, what we've seen in recent years off the back of all of that is that the battleground for the control of the media has shifted from the courts to media regulatory bodies, whose independence has been removed by authorities, and these authorities have been instrumentalized to target critical media. So we see this in the Public Advertising Agency, in the broadcast regulator, RETUC, and of course in the recent social media law, which was rushed through Parliament last October, that we see a landscape where the space for dissent, for criticism online, which was really kind of the last bastion of independent media, that's now being really squeezed through less dramatic forms. So we're not seeing the mass incarceration of journalists. You know, at the moment, there are all of those who are still in detention and who were not given any of the you know, there was a, in the context of COVID, there was a prisoner release strategy and policy, but journalists who were in detention were excluded from that. So those journalists remain in detention in very concerning health circumstances. But we see this squeeze on the media through all these other forms, which are largely administrative and through media regulatory bodies. You know, when you add that to a media landscape where at least 90% of the media is owned by pro-government individuals and companies, you know, we see really this full state capture of the media. And while there are a number of brilliant and extremely brave journalists who are continuing to carry out their work, the context, as you know, is extremely dangerous and difficult. So you risk, obviously, the risk of detention on overly broad terrorism charges, on criminal defamation charges. We know that Erdogan has more cases against journalists and social media users on charges of presidential defamation than any other leader in the world. But we also see many journalists who've had to go into exile, who have gone into exile to avoid detention or indeed assassination. We have an extremely alarming political rhetoric from not just the president, but from many of the nationalist politicians, you know, which is extremely anti-journalists, anti-critics, which makes for a very, very physically dangerous situation for journalists. And of course, we see complete impunity for attacks that have taken place against journalists. So altogether, you know, this is the context that the media is trying to the independent media is trying to operate in Turkey, and we've had annual meetings now with the Turkish Constitutional Court, with the Yargıtay, the Supreme Court of Appeal, with the Ministry of Justice, and we've really highlighted, you know, that at the heart of this lack of a fair trial, you know, is really those constitutional amendments, which, you know, led to the creation of the board who appoints judges and prosecutors, and that, you know, without reform to how judges and prosecutors are appointed in Turkey, everything else, you know, that the Turkish government have lauded through their judicial reform strategy and human rights action plans really is completely superficial window dressing. Because what you now have, as everyone has mentioned, a captured judiciary. You have, you know, the mass dismissals of judges, their replacement with state-appointed pro-government judges. So you have no expectation of a fair trial. Mm-hmm. And so these are all of the problems that we're seeing. And so, yes, while there are less journalists in detention. There are still at least 67 in detention at the moment. You know, we have all of these other issues to contend with, which makes for, you know, a very bleak situation.
Thank you so much for Sarah for drawing such a, I would say, perfect picture of this very complex situation, because I mean, really, you mentioned the media capture, which has been done by the state in Turkey, and then there is, let's say, a 10% of the media who somehow continue their work, but always under threat. Maybe it would be also helpful to underline how these state institutions, regulatory boards, public ads agency, and so on, are threatening the rest. I mean, the independent or non-governmental, I would say, media. They are being threatened through fines and penalties, and if they get one more penalty, it would mean for a TV channel to get closed. And so this has an enormous chilling effect on the media. But despite this chilling effect, because there's also I would say, a great support of the public online, I would say, more. Nowadays, it's also hard to go to take the streets in Turkey or to demonstrate and so on. These freedoms are getting more and more restricted every day. Well, they just keep on doing their work, and I would say my colleagues in Turkey are really courageously, they are doing their work with courage and dedication. And I would like to come back to you, Emma, at that point. We've talked about this chilling effect on the media, and you were also telling us about how the situation in the judiciary creates a chilling effect on NGOs. I mean, like, journalists can be called or accused of being terrorists, also ordinary people, or as we see in this trial of Osman Kavala, people who've been working along with him, or who just accidentally, whose road has just accidentally crossed with him, could be also accused of, just for doing some NGO work, could be accused of being involved in terrorist activity or espionage or something like that. And well, when we look at the evidence, we don't see anything about these accusations. Altogether, there are some cases. Maybe they would make it more clear for our viewers and to understand the situation in Turkey. And also, I would like to ask our viewers, if you have questions, you can please, you can write them in Q&A section or chat. If you have access, we can, we'll try to answer your questions after our panel. Yes, please go ahead, Emma.
Yes, well, I mean, I think at the heart of the problem is the instrumentalization of the criminal justice system against perceived critics. And as Sarah said, that's journalists, that is the entire civil society, lawyers, academics. It's such a range of people. And the great problem, and I'll talk a bit about the Osman Kavala case in a minute, is the use of the category of terrorism crimes and crimes against the state to go after people the government essentially doesn't like. And so the courts and the prosecutors really these days are acting under full government control. I've just spent, last week I was at court observing court hearings in Diyarbakir, in the heavy penal court, one of the heavy penal courts there. And in the people who came and testified were people who'd been involved in civil society and in some kinds of political activism. But all of the evidence, I mean, all of the cases that came before that court on that morning that I watched that court were about activities that are actually protected under the European Convention. So that's the right to assembly, the right to association, it's political activities, non-violent political activities, speeches, expression. And so the main problem with the use of these kinds of prosecutions and this kind of instrumentalization of the criminal justice system is that people cannot foresee that they will be later accused of committing a crime that's a terrorist crime. So you've got crimes that are, activities that are protected under the convention, which then become rewritten as a link to terrorist organizations, but without providing any evidence of violence or of incitement to violence, logistical support for violent or criminal organizations. And that's where Turkey's, really needs to reform these laws in a root and branch way and reform the implementation of these laws. But Turkey so far rejects to do that. And at the Universal Periodic Review of Turkey, which took place, it's the UN review of Turkey that takes place, every country, every 5 years, reviewed by other countries. Turkey actually said when it was challenged criticized for its anti-terror laws, no, we're perfectly happy with our laws as they are, and then nothing's going to change. And we think that our judiciary is independent, and that's not going to change either. The Council of Judges and Prosecutors, we're happy with it as it is. So faced with that kind of resistance, it's going to be very hard to get anywhere at the moment. And I think we've seen that played out in the struggle over the case of Osman Kavala and the Gezi Park trial, which is the trial of Osman Kavala and 15 others. But really, Osman Kavala is the big target there because he's the one held in prison throughout for over 3.5 years now. And the European Court of Human Rights found that there was insufficient evidence to hold him in detention, both for alleged involvement in the Gezi Park protests of 2013 and also alleged involvement in the 2016 July 15th military coup attempt. On both these cases, the European Court said no, insufficient evidence, and the fact that he's been continually detained in the way he has, the detention prolonged, is a sign that Turkey is misusing the convention, misusing the restriction on rights in the convention, the permissible restrictions, in an entirely political way, and using detention as basically a political tool to keep someone silenced. And Osman Kavala has been kept silent. And we see exactly the same kind of conclusion in relation to politician Selahattin Demirtas. Now, what's so depressing about the Kavala case is that the court decision is so clear, and that the implementation of this decision, which happens by the Committee of Ministers of the Council of Europe, is an ongoing process. And I think we've seen an unprecedented level of engagement by the Committee of Ministers. Now, the Committee of Ministers, for those who don't know the Council of Europe structures, Committee of Ministers is actually the foreign ministers or the deputy foreign ministers of all the Council of Europe member states. So they get together, they have these sessions every quarter to talk about human rights. And Osman Kabala's case comes up repeatedly every time. We've had now 6 decisions from the Committee of Ministers on Osman Kabala's case and 1 interim resolution. Now, interim resolution just means a kind of a stronger form of decision about the case. And each decision and resolution has said, this man has to be released. The evidence was insufficient. He's being held on in a politically motivated process. And each time Turkey has so far flouted that. But we've come to a very critical point now with this, because just last week, the Committee of Ministers said to Turkey for the first time, and I'm going to sort of quote, they expressed a determination that the implementation of this judgment would happen, that he would be released, and they would use all means at their disposal, including opening infringement proceedings against Turkey. Now, infringement proceedings, again, you know, lots of journalists ask us, what are infringement proceedings? But actually, yes, infringement proceedings don't include monetary fines directly or, you know, sort of penalties of that kind, sanctions of that kind. They are rather a process, infringement proceedings is a process of steadily shaming the state concerned over its failure to implement a binding European Court decision. And that can turn into Turkey being denied voting rights at the Council of Europe level. And eventually it could even turn into expulsion from the Council of Europe, which would be an unprecedented step if it happened. But it does show that internationally, over that case of a civil society leader unjustly jailed and prosecuted, there is a resolution from the Council of Europe to focus on the case and to take the necessary steps. And that's what has to happen. It can't just be part of a bargaining between Europe and Turkey. This is not about migration. This is not about the East Mediterranean. This is about the implementation of a binding court decision, and one of the most important, and it sets an enormously important precedent for all the other cases before the court concerning Turkey.
Thank you, Emma. Patrick Henry, as the chair of the CCBE Human Rights Committee from 2013 to 2019, you also witnessed some attempts on fair trial in Turkey. Maybe upon Emma's examples and statement commentary, you could also add on some other sorts or cases of attempts on fair trial.
Try to be concrete, and so I will illustrate the violations of fair trial principle with the findings of a report by 15 European lawyers from 7 different countries who followed the trial that led the Istanbul High Criminal Court in March 2019 to sentence 18 Turkish lawyers who were members of the Progressive Lawyer Association, including Ebru Temtik, to sentence ranging from 18 years and 9 months to 3 years and 1 month and 15 days for founding and leading a terrorist organization, participating in a terrorist organization, or knowingly providing support to a terrorist organization. The court was presided over by Hakim Gürlek, who was also in charge of the trials against Selahattin Demirtas, one of the 2 HDP presidents, Kenan Kaftancioglu, the Istanbul CHP president, the famous writer Ahmet Altan, Sebnem Korfu-Fincanci, the president of the Human Rights Foundation of Turkey, and the theologian Hisan Elyakşik. The group concludes that the following procedural rights were violated. 1. Right to an independent and impartial tribunal. For instance, the judge uses a familiar form of address toward defense lawyers instead of the polite form. He was interrupting the accused and defense lawyers during their speeches and switching off their microphones. He rejected all requests without taking an appropriate time to examine them and to confer with the two other judges. He issued a warning to the lawyers when they submitted a request to challenge the composition of the court, noting that it would be considered as a contempt of court, before rejecting the request and refusing to suspend the hearings in order for the appeal to be examined. Second, right to participate effectively in the proceedings. For instance, heavy presence of police forces inside the courtrooms, close to the defense and on the benches, preventing the accused lawyers from communicating with the defense lawyers. Third, equality of arms and limitation of the rights of the defense. Removing a lawyer after it demonstrated that a witness was lying. Limitation of number of lawyers authorized to defend the accused. Removing from the courtroom of accused lawyers. 4, right not to be tried or punished twice. 8 of the lawyers were defended in the 2 cases. 5, right to have adequate time and facilities to prepare one's self-defense. Some accused were denied the right to access their files. Denial of time to prepare the defense or to prepare the hearing of witnesses. 6, right to publicity of the debate. On 3rd December 18 and 19 March 20, after a decision forbidding all the defense lawyers to enter the courtroom, the public, which protested, was also excluded from the courtroom. 7, right to examine and to obtain attendance of the witnesses. Refusal to hear witnesses admitting to be put under pressure by the police. Refusal to hear any witness from the defense list. Hearing of anonymous witnesses, often with a repentant status. 8, right to cross-examine the validity and proof and present proofs. This trial also brought to light flagrant violation of the basic principle of the role of lawyers as adopted by the United Nations in Havana in 1990, namely the right to consult a lawyer in detention, the interdiction of identifying lawyers with clients, the lawyers who were charged with membership in a terrorist organization because they were defending alleged member of that organization. The CHD lawyers have been prosecuted because they were defending, with respect to their professional duties, standards, and ethics, persons accused of being member of a terrorist group. Moreover, their defense lawyers were many times threatened with sanctions even while pleading during the CHD2 trial. That's among the most conclusion of this group, but the report is from more than 40 pages, and it is difficult to make more than a short summary.
And the findings here you've mentioned are also reasons why, well, Ebru Tümtek isn't with us today. And the Turkish government was told about it. The Ministry of Justice, the government, judiciary. Sarah, I would like to come to you now. But before that, let me just tell to our attendees once again that you're free to ask your questions in the Q&A section or in the chat section. Sorularınızı, and once in Turkish, because you can also ask in Turkish. Sorularınızı Q&A ya da chat bölümünde yazabilirsiniz bizi izleyenler. Sonunda hızlı cevaplar almaya çalışacağım panelistlerimizden. Back to English now. Sarah, I would like to come to you because, you, Article 19, along with other rights organizations, or you yourself, were, as you mentioned, had the chance to get together with government officials in Turkey. And then there's this obvious picture of unlawfulness and everything, lack of fair trial and non-implementation, I would say. How do they respond to these? What are they expecting? I mean, these procedures are actually well-known procedures. Were they hoping that the Committee of Ministers is going to say nothing about it, or they think it's not important or nothing will come out of it? So how do they defend themselves? And what do they expect, actually? Because they also claim to have independent judiciary and, well, yeah.
Yeah, so I think the narrative has shifted a little over the last number of years. In the initial years after 2016, the narrative was very much one of a national security justification for everything. There was a very defensive posture, which was that the international community does not understand the level of threat that Turkey is facing. And there was a lot of anger at the perceived lack of solidarity with Turkey on combating the attempted coup, and for any of our criticisms in those first years were met with, you don't understand the level of threat, and we're doing this out of national security. Now, that line shifted somewhat in maybe from 2018 onwards, which was more that, because we've had to reappoint so many judges, it will take them time to understand how to implement judgments, or we need more training. So sort of a buying time argument has been used a lot. And, I think that's why the Council of Europe, for example, is undertaking so many projects with the Turkish Ministry of Justice around, training of judges. Our argument with that, especially when it came to the non-implementation of European court decisions, the non-implementation of Turkish Constitutional Court decisions by lower courts. So you'll remember in the cases of the Altons, we had a non-implementation of the decision on Mehmet Altan and Şahin Alpay for many months. So that was argued, and I would say, deeply unconvincingly, that lower courts don't understand what precedent means or the authority of the higher courts. When it comes to the argument, like we also had, a lot of concerns about the delay in judgments from the Constitutional Court. So our arguments were always around the non-implementation of decisions, the extremely long delay in having cases, having decisions on cases like the Wikipedia decision, for example. And then the lack of consistency between decisions. So you would have decisions on very similar facts, but with completely different outcomes. So like Mehmet Altan and Ahmet Altan, they were like totally different outcomes. So the arguments there were always that, this is an independent judiciary and there's no political interference. But, you'd be sitting in a room with the Constitutional Court judges whose colleagues had been detained after the coup. So we know that, very serious principles like the irremovability of judges has been completely eroded in a situation where you've had thousands of judges removed and replaced. When it comes to the Ministry of Justice, the argument now is very much, we have a judicial reform strategy, we have a human rights implementation strategy, and this is how we are engaging with the international community, with the Council of Europe. And again, those arguments are very flimsy. They're very weak, because on none of the really crucial issues, such as meaningful reform of the terrorism law, or even more importantly, the High Council for the appointment of judges and prosecutors, nothing has meaningfully changed there. And that's always been our argument. That was our argument at the UPR. It's our argument in Strasbourg, where for years we've been pushing Strasbourg to make faster judgments on decisions relating to journalists, decisions relating to Demirtas and Kavala. We've worked a lot with Human Rights Watch on all of that. And now, thankfully, we do have decisions, because we didn't have them for 4 years in some cases. And as Emma says, you know, that's what has pushed the Council of Europe and the Committee of Ministers into this standoff now, where they're talking about infringement proceedings. And I think, you know, for a long time, possibly the reason for the delay in those decisions was because they were concerned this is what it would lead to. And what's really worrying, I suppose, Banu, is, you know, the international institutions have never been very strong on Turkey. The EU weren't because of the refugee deal and security concerns. The Council of Europe weren't for other reasons. But now we are at the point of this, what was always an inevitable confrontation, because Turkey has not reformed in any meaningful way 5 years on from the attempted coup.
Mm-hmm. So we are running out of time. So I would like to mention one small but important thing before coming to you, Emma. Well, I mean, we talked about the reaction of the Committee of Ministers. Now, I mean, how the committee reminds Turkey of its obligations, but it's not the case only about the European Court of Human Rights decisions, the non-implementation of that, but also you said that Turkey is misusing it's how should I say, the whole sphere of law. It also happens when it comes to Interpol. I mean, Can Dündar, a very well-known journalist, is being politically, I would say, persecuted just because he had done his job before, publishing a story with also visuals of the Turkish government and intelligence smuggling weapons to Syria, illegally actually, or undercover operation, in an undercover operation. So that's why he's being persecuted. And then there is a second attempt of the Turkish government, actually through the National Central Office of Interpol, a request to Interpol at headquarters to issue a red notice on Can Dündar. And Interpol headquarters stated that previously they rejected such a request. And there comes the second one. I asked them how they formulated their rejection, what they said to Ankara. And then I quote, "The General Secretariat has reminded the Interpol National Central Bureau in Ankara of its responsibility to adhere to the organization's rules and constitution, in particular Article 2, to ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of laws existing in the different countries and the spirit of the Universal Declaration of Human Rights." And then Article 3, under which it is strictly forbidden for the organization to undertake any intervention or activities of a political, military, religious, or racial character. So the Interpol is also replying Turkey, not only regarding the request on Can Dündar, but also regarding some other requests, I believe, this way. So I would like to just add up at this, and then back to you, Emma. Now, Sarah told already about the statements made by Turkey, made by the Minister of Justice, you know, about this law reform. I would like to hear from you what you hear from the Turkish authorities and what we should expect from this so-called law reform.
Well, we've heard lots of promises of human rights action plans and law reforms, and so far they've not been worth more than the paper they're written on, unfortunately. They're either a very general statement of principles, which someone in the first year of a law degree would be presented with as a topic, or they're just, you know, things that will never be implemented. So I think it's very difficult in this period to believe in the possibility of a real reform agenda as far as judicial reform. And I think, you know, as far as us, I mean, we get answers when we present findings and reports to the Turkish government. We often either get no answer, or we actually get answers through the Committee of Ministers at that level. So we're rather keen to engage at the Committee of Ministers level over the cases of Demirtaş and Kavala, because that way we do get an answer from the Turkish government in writing, and it's a public answer to the Council of Europe. So that's very good. And we don't find they mainly tackle the points we raise. There's a sort of, they change the subject and talk about other things. So it's not a particularly useful dialogue. It's rather a dialogue of the deaf, I would say. But I wanted to go back to one point here, which is because we are talking about rule of law and unfair trial, and a pattern of the present that I think deserves to be mentioned here, because it does affect so many of the trials we're talking about, including the trials of lawyers and the Progressive Association of Lawyers trials too, is the use of secret witnesses and witness evidence, which really is extremely vague and never properly scrutinized in court. So we've got a pattern in many of the prosecutions we're seeing and the trials we're seeing of secret witnesses appearing who may be able to be questioned in court, but what they actually say is so general and vague that it really doesn't meet the threshold of being reliable evidence or considered something that should be considered as evidence. Just by merely stating that a defendant is a member of a terrorist organization doesn't prove they are. And the courts are very unwilling, the prosecutors especially, to actually interrogate this evidence. And the court, we've seen the panel in the court unable to sort of ask the real questions of these witnesses about how they come to know that someone is guilty. And this evidence is used to convict people, along with social media posts and other things to sort of make the file look substantial. And it's a real pattern in the present. And I think that that's something we should put into this discussion, because I come across it so often. The other
could you please add something on the situation of academics in Turkey? Yes,
now on academics, academics is a different matter altogether, because I mean, many people were dismissed under the state of emergency, many academics. The ones that are particularly worth mentioning here, because they have a case before the European Court that hasn't been tackled for 4 years, are the peace academics. Now, the peace academics signed they're so-called peace academics, they signed a declaration in January 2016 calling for peace. And it was a document that was just squarely within the boundaries of free speech. For this, 406 of them got dismissed from their universities, over 1,000 signed. 406 got dismissed from their universities. They all got prosecuted. They all got acquitted, because the Constitutional Court found that acquitted, found a violation of free speech. And that led to a series of acquittals. But then the 406 who got dismissed from their universities have not been reinstated. Their cases are still before the State of Emergency Commission. And they've had no redress to date. They've seen no readiness to handle their cases. So it's very
prospects,
the European Court take up this case urgently and see it as a priority, because that case has been before the court for nearly 4 years. And it's a very important case that will determine what happens to many academics and set a very important precedent in Turkey.
Thank you very much. Well, actually, we've been talking about how much lawyers can contribute to reminding the importance of fair trial. Whenever there is an issue, they would, I mean, we journalists used to talk with them, like me talking to Ebru about one particular trial, or today if Selçuk Kozağaçlı would be free, I'm sure after this panel, I would just call him, give him a call, and we would talk about how the trial went today, how the hearing went today, and I would interview him. And also many others, you know, who are being threatened with trials, cases, and so on. And also the bars are important actors in reminding the society about fair trial, importance of fair trial. The importance of fair trial. And Patrick, back to you very shortly. This is also being threatened by a new law. I mean, in Istanbul, we have now 2 bars, for example. No, so it's also being politicized by the government. So here, another example of state capture. Or what do you think? Please unmute yourself.
You want to hear me about the new law on the bar structure? Yes, that's frightening for us. And you know that on the 15th July 2020, there was a new law, number 7249, which entered into force, and modifying the electoral system of the Chamber of the Bar and further restricting the independence of bar association. This law alters the number of delegates provincial bar association can send to the Union of Turkish Bar Association, mostly affecting the bar association representing the largest number of lawyers, by dramatically reducing the influence within the UTBI. The new law allows any group of 2,000 lawyers in provinces with over 5,000 lawyers to set up their own bar association, which could lead to several bar associations being created in big cities where bars are representing a large number of lawyers. This results in a lack of proportionality and breaches core principles of democracy, which will consequently hinder the independence, integrity, and freedom of expression on the legal profession. What we can do about that, it's difficult. Lawyers are fighting with words. That's more than nothing but words aren't weapons of massive destruction. I think conviction for breaching the human rights do not scare the President Erdogan. President Erdogan is not a fan of human rights. But Turkey is member of the European Council and of the CCB. It depends also of the Strasbourg Court. And so what we can do is to speak again and again, to testify, to denounce human rights violation, to ask for conviction of the Turkey in Strasbourg, because it helps those who in Turkey fight for their rights. That's not much, but that is something, and I think we will have to continue. Deranim.
Thank you very much, Patrick. Now it's time to wrap up with questions, and I am going to direct the questions. I mention them all together, and maybe direct one or two of them to particular participants. Emma, this one is for you, I guess. Are there any cases known about human rights defenders or lawyers who disappeared? This is a question, but let me ask the others as well. Please note down your questions. And there is a question from Ayşe Bingöl. My question reflecting on an ongoing discussion we all have among ourselves. When it comes to what the international community has been doing to address the issues in Turkey, in their view, what has been working, making an impact, and what has not? And also Irma Vanderberg is asking a question. We know there are so many people being prosecuted that we do not even know of. And in the case of Lawyers for Lawyers, lawyers being prosecuted, we do not of. Do you or your organizations have a strategy to find out about all the cases that are going on? There was a similar question from Tony Fisher. He'd like to ask you whether or not you feel there are any other coordinated actions which have not already been tried, which could be taken by the European Bar Associations and Judges Associations that might have greater impact in terms of encouraging Turkish authorities to respect the independence of judges and lawyers. Yes, I guess that's all as for questions. There's one new more, yeah, okay. These are informations posted by Ayşe Bingöl Demir, I guess. Yeah, so please go ahead, Emma. And we don't have much time left. So
okay.
If we could wrap it all up, the three of you, in 6 minutes, please go ahead. 2 minutes each, yes.
Okay, so my question, the first one about abduction, about disappearances. I do not know of human rights defenders and lawyers who've been subject to enforced disappearances. However, saying that, you know, there are enforced disappearances in Turkey. There are a few dozen enforced disappearances. The identity of those people is not human rights defenders and lawyers. They're mainly disappeared because of their alleged association with the Fethullah Gülen movement. But the point is not to look at that. The point is to look at this as an egregious crime, you know, and one of the most alarming manifestations of the breakdown of the rule of law and bypassing of all law and process. There are also abduction-style disappearances of people in countries with weak rule of law frameworks. And these people, I mean, I was going to say this earlier, when we talked about Interpol, Turkey putting out red bulletins for people's return, like Can Dündar. In other cases, Turkey doesn't even do that and actually sends members of its intelligence services to actually cut a deal with authorities in countries with weak rule of law frameworks where they bypass local law and bring people back to Turkey forcibly. And we've seen that again with people, particularly teachers, from the Gülen movement in different countries. And, you know, that is really another manifestation of the egregious bypassing of rule of law. And one of the things that risks those people face is an almost absolute risk of lack of fair trial, almost inevitably so, and we often point that out. On the other questions, I would just say, I mean, impact issues. I think pushing at the attempt to sort of push at the Committee of Ministers level is an important one, because I think Turkey still does care in some way about how it's seen in international fora. And, you know, having things on record in these fora is important still. However much people say, well, they just don't implement the rulings of the court, they don't heed the reports of the UN special rapporteurs. I think it is extremely important. And having Mr. Garcia Sayan in the room, I really want to say this. We think it's really important that you visit Turkey. We will all do all we can to make your visit happen, because this is you are the special rapporteur who perhaps most needs to come to Turkey to look at the structural problems of the criminal justice system the lack of independence of judges, prosecutors, and the erosion of the role of lawyers. So just make that statement while you're in the room, Mr. Garcia Sayan.
Thank you, Emma. Patrick?
I have already answered partly in my last intervention. I want to say that the CCBE has as a member the UBTA. So the Turkish bar are member of the CCBE. The Turkish lawyers can go to Strasbourg court. And I think there is something very important to defend the human rights in Turkey. For the rest, what is important is to have links with the association who are working in Turkey. We try to do it. It is always a work to be renewed. And that's something very important, I think. You know, at this time, the world is not in the world. Human rights are not no more universal standard. In some countries, the human rights are seen as the product of the capitalism, the triumphalist capitalism, and a sort of egotism. I think human rights are for everyone, and thanks to Ebru Timtik and to other lawyers who remind us.
Thank you very much, Patrick Henry and Sarah Clark. So,
Thanks, Banu. Yeah, I would agree with Emma that I think this push at the Committee of Ministers has been very important. I think we also need to, as we're looking at novel ways of putting pressure on Turkey, I think we should, continue to look at Magnitsky-style individualized sanctions against those high-level officials complicit in human rights abuses. Those types of sanctions require a huge amount of documentation, and I think a lot of the lawyer groups here, could be very useful in sort of putting together some of that documentation. We spend a lot of time working with investigative journalists who are investigating corruption, which is obviously a massive issue in Turkey, and we come at it more sort of from that angle, looking at sanctions around sort of those involved in corruption. But I think, we've seen a number of high-level initiatives, including the high-level panel chaired by Amal Clooney and others, really pushing that Magnitsky-style sanctions should be used against those individuals complicit in human rights abuses and in abuses against journalists. So that would be a food for thought from my side to see how we can get more organizations involved in that type of work.
yes. I would like to express my thankfulness to the panelists. So it was a very, very clear picture at the end of the very, on the one hand, simple fact that there is no rule of law nowadays in Turkey, and a big lack of fair trial. And also of this, at the same time, of a very, very complex situation where we see the judiciary, the captured judiciary and the government finding new ways of politically persecuting people in all aspects, actually, in all different fields. So I would like to thank you, Emma Sinclair Webb, Patrick Henry, and Sarah Clark for this discussion and panel, And now it's time to continue because it took longer than we thought. Without a break, it's time to continue with Ebru Timtik award ceremony. And here I would like to leave the floor to Tony Fisher, the from the Law Society of England and Wales, and member of the steering group of the International Fair Trial Day. Thank you, Tony, and the floor is yours.
Thank you very much, Banu. And yes, we now move into the second session of this conference, which is the Ebru Timtik Award ceremony. When members of the steering group first began to discuss the International Fair Trial Day, it was felt that something additional should be organised to ensure that Ebru's name remained in people's memories and that her dedication and her sacrifice would be remembered each year at the same time as the International Fair Trial Day itself. We therefore conceived of an annual Ebru Timtik Fair Trial Award to be granted to one or more individuals or an organisation which has demonstrated outstanding commitment and sacrifice in upholding fundamental values relating to the right to fair trial. Each year, the award will be given to an individual or an organisation from the focus country who's been active in defending or promoting the right to a fair trial in that specific country. This will include individuals who have themselves been victims of a violation of the right to a fair trial. In view of the fact that Ebru herself made the ultimate sacrifice in support of fair trial rights, we felt it was appropriate that at the end of this inaugural International Fair Trial Day, the award should be made posthumously to Ebru herself. The nomination process for next year's award will commence in September this year and close on the 15th of December. Nominations will be accepted from established organizations or groups of individuals, and further details of the criteria for the award will be circulated later in the year. For this year's award, an artwork has been commissioned, and we'll be hearing from the artists shortly. They will make a short presentation with regard to the concepts which lie behind the artwork before a video incorporating the audiovisual element of the artwork is shown. We're hopeful that the physical element of the artwork will make a tour of National Bar and other interested associations and galleries on its journey to Turkey during the course of this year after this event. Here to make this inaugural award, I'm delighted to welcome Dominique Attias, the current president of the Federation of the Bars of Europe, and amongst her many other achievements, also a former vice president of the Paris Bar. So I'll give the floor to you, Dominique.
Thank you very much. Her death is a murder, reminds us Ceren Uysal, her Turkish friend and colleague, responsible for the Association of Progressive Lawyers. Ebru Timtik, her ardor, her courage, her smile, her eyes so lively, underlined by voluntary eyebrows. She is dead, carried in the ground by 12 of her colleagues, mourned by all of us. Ebru Timtik loved life so much, fond of poetry and Zaza music. She was claiming her Kurdishness and loving Turkey, her country. Nothing or no one could bring down this icon of the struggle of human rights in Turkey. Look at her, screaming freedom at the top of her lungs of the steps of this sinister courthouse that Stalin could have been proud of, a courthouse in the image of a dictator. What has become of their Turkey that Ebru loved so much? The country of the sweetness of life that is now moving away in the mortifying way. a country that now dares to state that the lawyer of a terrorist is a terrorist. The negation of the principles advocated by the countries that are part of the Council of Europe. She was the joy of life and courage embodied. She was the one who assisted the family of Birkin Elvan, a teenager who died in 2014 as a result of injuries received during the anti-government protests in Gezi Park in 2013. She was also the one who stood by the families after the massacres of Kurdish civilians in Syria in January 2016. Nothing and no one, including Erdogan henchmen, were afraid of this emblematic woman, Ebru Timtik, a reed that nothing could bend. Once again, she went into battle with 16 of her colleagues, including her sister. We think on her. Her sister, Birkin Timtik, to defend clients qualified as terrorists by Turkish authorities. She was appearing with her sister and fellow fighters on September 10, 2018, in front of the 37th Criminal Chamber of Istanbul Court at Barkinoy Courthouse during the CH2D2 trial. I was there. What a joy when I learned on my return from Turkey that on September 14, 2018, they had all been released. But what a disillusion. The next day, when this same chamber decided, after an appeal by the Public Prosecutor's Office, to return 12 of the released lawyers, including Ebru, to detention. After a parody of a trial, the court suddenly interrupting the debate, condemned to a heavy sentence, 13.5 years in prison, and incarcerated on June 20, 2019, following this conviction. Who could have imagined at that time that every day of detention would bring her closer to death? For all of us, she was invincible. On January 3, 2020, Ebru Timtik began a hunger strike to demand a fair trial, and in particular, that her appeals be examined. On April 5 of the same year, she announced that she was turning her strike into a death fast. Who keeps in memory her now tiny body and her big smile, the last image of her? She had lost 30 kilos, but continued to have faith in her fights. Irreducible Ebru, she died, her coffin covered by red carnations. Did her colleagues who took her to her final resting place knew that the carnation is used as a symbol of women's struggle for their rights? Ebru was not fighting for her rights, but for the rights of others, for the right of the true justice for her clients, the right to live in a free country. Death took her away on August 27, 2020. Since then, we mourn and honor her as we do today. all the bars of Europe for the first time together on September 7, 2020 at 12 stopped to express their solidarity, to think of her, and to say that our support to the prisoned lawyers will not weaken. She took her leave and probably saved our colleague, Eta Kunchal, who was incarcerated with her on hunger strike for 213 days. He was released by the Turkish Supreme Court, a final gift from Ebru. She is here among us and asks us to continue the fight for the livings. This is our message to the torturers. The European Bars Federation and all the associations will continue to support our courageous and unjustly imprisoned colleagues in Turkey and around the world. Never, never, no matter how long the trials are, how many times are postponed, no matter what the puppets at the head of your courts do, the lawyers of the world will never give up. Ebru will stand by us no matter what you do. Thank you.
Well, Dominique, thank you very much for that very powerful and passionate speech. And I'd now like to pass over to the three artists, Kay Parker, Judd Moses, Druce, and Caroline Wright, who have created a poignant and powerful artistic tribute to Ebru, which we'd now like to share with you. So Caroline, Judd.
Thank you for the introduction, Tony. We were delighted to be chosen to create an artwork to honour and respect the life of Ebru Timtik, one that would be presented to the human rights lawyers' family on the occasion of this first International Fair Trial Day. The work, entitled 238, has been created within a structure formed out of data that relates to the life of Ebru and her fight for justice, realised visually and in sound as two cross-referencing elements that can be experienced collectively or individually.
The sound work takes significant numerical references to structure the composition. For example, the piece lasts for 238 seconds, length in days of Ebru Timtik's hunger strike. In a generative and diminishing sound pattern, references to Kurdish rhythms and instruments are woven into the piece, mixed with recordings of Ebru's voice.
The sonic composition represented visually as sound wave forms has been transferred into textile work the size that references a blanket, a familiar form, that simultaneously covers, holds, protects, and reveals the form of a body. The design, realised in a selected colour spectrum to represent all peoples, as well as acknowledging memories of Ebru's life through colour, uses printed surface pattern and applied stitchwork incorporating the words "for all the vulnerable" to recognise Ebru's fight for the rights of all people.
We would like to congratulate everybody on this event and will now introduce you to the artwork through a short video that combines the sound with video footage of the printed textile. And I will just share my screen.
Well, thank you very much, all of you. Very moving and, as I say, poignant tribute to Ebru. And as I said earlier, we're hopeful that that it will be traveling around bar associations within Europe on its way to Turkey. Thank you for all your dedication in putting the works together. And now finally, I'd like to introduce Attorney Seda Seraldi from the People's Law Office, Ebru's Law Office, who will accept the award on behalf of the family of Ebru. Perhaps I could hand the floor to you, Seda. And perhaps Caroline, you could stop sharing your screen actually.
Merhaba. Bugün bizim Ebru ablamız adına, Ebru Timtik adına verilen bu ödülü onun şahsında büromuz adına, onun ailesi adına kabul etmekten büyük bir mutluluk duyuyorum. Bundan bir yıl önce Ebru ve Aytaç adil yargılanma hakkı talebiyle ölüm orucuna devam ediyorlardı. Bizler bütün bu süreç boyunca onların yanında olduk. Yurt içinden ve yurt dışından dostlarımız destek ve dayanışmalarını ilettiler. Dünyanın her yerinde Ebru ve Aytaç'ın isimleri duyuldu. Başka yerlerde sokaklara isimleri verildi. Onlar için törenler düzenlendi, anmalar yapıldı. Bunu sağlayan bütün dünyadan avukatların ve halkların dayanışması oldu. Ebru ve Aytaç bu yönüyle aslında bizlere neler yapabileceğimizi, ne kadar güçlü olduğumuzu gösterdiler. Ancak zannederim bize asıl gösterdikleri önemli şey adalet için nasıl mücadele edileceği oldu. Bıkmadan, usanmadan ve bedellerini göğüsleyerek. Ebru ve Aytaç, büromuzun adalet mücadelesinde yarattığı örneklere bir yeni halka daha eklediler. 1994'te polis tarafından infaz edilen büromuz avukatı Fuat Erdoğan'ın yarattığı, 2007'de müvekkillerinin hapishanelerdeki tecride karşı başlattığı ölüm orucunda bir avukat olarak yapabileceğim her şeyi yaptım dedikten sonra ölüm orucuna başlayan Behiç Aşçı'nın yarattığı geleneği büyüttüler. Halka uygulanan her türlü baskının, hukuksuzluğun karşısında olduk. Yoksul mahallelerde yaşayanların, evleri yıkılmak istenenlerin, gece yarısı baskınıyla gözaltına alınanların, demokratik haklarını kullandıkları için suçlananların avukatlıklarını yaptık. Halkın yanında olduk, hukuk bilgimizi halkın yararına kullandık. Elbette halka yöneltilen her saldırıyla da karşı karşıya kaldık. Büromuz kuruluşundan bugüne her türlü saldırının hedefi oldu. Bürolarımız basıldı, çalışma arkadaşlarımız gözaltına alındı, tutuklandı, hakkımızda yıllara varan cezalar verildi. Adaletsizlik mesleğimizi yapma biçimimize yöneldiğinde, yani devrimci avukatlık tarzımıza yöneldiğinde direnmenin, karşı koymanın her türlü yol ve yöntemini araştırdık. Ebru ve Aytaç bedenlerini siper ettiler adaletsizliğin karşısına. Halkın avukatlığının, devrimci avukatlık pratiğinin karşısında saldırıların boşa çıkacağının göstergesi oldu direniş. Hak savunmanlığı mesleğini içselleştirmeden Ebru'yu ve Aytaç'ı anlayabilmek mümkün değil diye düşünüyorum. Ölümüne bir direnişi nasıl sırtlandıklarını anlayabilmek mümkün değil. Bunun için Ebru'nun ve Aytaç'ın meslek pratiklerine bakmak gerekir. Neler yaşadıklarına bakmak gerekir. Biz sorgusuz sualsiz katledilen müvekkillerimizin cenazelerini otopsilerinden sonra teslim aldık. Ölüm oruçlarında, açlık grevlerinde hayatlarını kaybeden müvekkillerimizin cenazelerine katıldığımızda gözaltına alındık. İşkencelerden sonra ayakta duramayan müvekkillerimiz bizlere tutunup hakim karşısına çıktılar. İşkencelerin cezasız kaldığını gördük. Ülkemizde yaşanan her türlü adaletsizliğin en yakın tanığı ve birebir muhatapları olduk. Bu adaletsizlikler anlaşılmadan adaletsizliğe duyduğumuz öfke ve adalete duyduğumuz özlem anlaşılamaz. Bu öfke ve özlemle gün geldi şehirler boyu yürüdük, çadırlar açtık, imzalar topladık, eylemler yaptık. Dünyanın her yerinde halkların uğradığı adaletsizliklere karşı durduk. Örneğin Suriye halkının uğradığı katliamlara karşı 2013'te dava açmaya hazırlanırken Ebru'nun da içinde olduğu büromuz avukatları tutuklandı. Hem 2013 yargılamasında hem de 2018'de yapılan yargılamada adil yargılanma hakları ihlal edildi. 2018'de bir yıllık tutukluklarının ardından 5 gün süren duruşmalarda onları dinleyen ve haklarında tahliye olmaları gerektiği kararını veren heyet dağıtıldı ve daha düşük görevlerle dağıtıldılar. Yerine yeni bir heyet oluşturuldu ve haklarını tekrar yakalama kararları çıkarıldı. Ve Ebru abla bu yakalama kararını tanımadı. bürosunda bir sığınakta bulunana kadar bu adaletsizlikten kendini gizleyebildi. Dağıtılan heyetin yerine gelen heyet onların son sözlerini bile dinlemeden haklarında hüküm verdi. Haklarında verdiği hüküm 18 avukat hakkında toplamda 159 yıllık cezayı kapsıyordu. Hem 2013 hem de 2018 yargılamalarının temelini gizli tanıklar oluşturuyor. Her iki dava %70 oranında benzer. Aynı nedenlerle 2 kere dava açıldı. Ceza yargılaması için temel bir ilke olan non bis idem ilkesi uygulanmadı. Gizli tanıkların söyledikleri arasındaki açık çelişkilere rağmen bunlar görmezden gelindi. Ebru Timtik, gizli tanıkların yalanlarına karşı ölüm orucundayken şöyle söylemişti. Ölüm orucu bir meydan okumadır. Canımı ortaya koyarak diyorum ki gerçeği biz söylüyoruz. İddianame değil. Türkiye'de Anayasa Mahkemesi Başkanı ihlal kararlarının yarısını adil yargılanma hakkına ilişkin verdiklerini açıklamıştı. Türkiye'de çok uzun süredir yargı bağımsızlığı, adil yargılanma ve savunma hakkı gibi temel ilke ve haklar tartışılır durumda. Hukuk güvencesinin olmadığı ve buna keyfi tutuklamaların eklendiği olaylar günlük yaşamımızın bir parçası haline gelmeye başladı. Sendikal haklardan, örgütlenme özgürlüğüne, iş güvencesi hakkından, doğal temiz çevrede sağlıklı yaşama hakkına kadar tüm hakların özlerine dokunuldu ve etkisizleştirildi. Ebru ve Aytaç'ın direnişi işte bu saldırılara karşı da yapılmıştı. Onlar mesleki ve siyasi olarak halkın avukatlığının, hak savunmanlığının varlığını korudular, güçlendirdiler. Bugün fiziken Ebru aramızda değil ama korumak için canını verdiği halkın avukatlığı geleneği Ebru'nun can suyuyla büyüyor. Ebru Timtik defterine Nazım Hikmet'ten bir alıntı not etmiş. Şöyle diyor Nazım Hikmet: İnsanın ülkesinde unutulmaması ne kadar önemlidir bir bilsen, hem de ölüm yakınken. Bugün bütün dünyada unutulmayarak onurlandırılıyor Ebru. Bizler onu her zaman onurla, cesaretle ve sevgiyle hatırlayacağız. Konuşmamı tutuklu müvekkilimiz şair Ümit İlter'in Ebru ve Aytaç için yazdığı bir şiirden 2 kıtayla bitirmek istiyorum. Sevgili Ebru, zorbalık tanrısının kızına neden inanayım adalet adına? Haksızlık saltanatının bütün sahtekarlarına yitirdim inancımı evvel zaman içinde. Sadece size inanıyorum halkın avukatları, halk olduğum için. Sevgili Aytaç, inancım tam, tanrıçasına değil, aşığına adaletin. Açlığınla savunduğun ne varsa inanıyorum. Gözlerinin aydınlattığı yarına inanıyorum. Ebru ile sana, cümlesiyle halkın avukatlarına inanıyorum, adalet aşıklarına. Teşekkür ederim.
Excuse me, I'm terribly sorry, Sarah, but unfortunately the translation appears to have stopped working, and I don't know what the technical issue is, but I wonder if you could just hold for a second whilst we try and resolve that. And perhaps when we have resolved it, we could go back a couple of minutes so that we hear all of the of your observations.
Çevrede sorun. Tekrar konuşma yapabilirim ama çevredeki sorunu anlamadım. Bekleyelim. Çeviri kanalında sorun oldu. Hı?
Yes, I can hear you. I'm speaking to the interpreter. Okay, thanks. So perhaps you could ask Seda to just go back a couple of minutes in her observations so that we can ensure that we don't miss anything. Thanks.
Son kısmı Tamam. Kısaca şunlardan bahsetmiştim. Türkiye'de Anayasa Mahkemesi Başkanı ihlal kararlarının yarısını adil yargılanma hakkına ilişkin verdiklerini açıklamıştı. Ve uzun süredir Türkiye'de yargı bağımsızlığı, adil yargılanma ve savunma hakkı gibi temel ilke ve haklar sıkça tartışılıyor. Hukuk güvencesinin olmadığı ve buna keyfi tutuklamaların eklendiği olaylar günlük yaşamımızın bir parçası haline gelmeye başladı. Sendikal haklardan, örgütlenme özgürlüğüne, iş güvencesi hakkından, doğal, temiz çevrede, sağlıklı yaşam hakkına kadar bütün hakların özlerine dokunuldu ve etkisizleştirildi. Ebru ve Aytaç'ın direnişi işte bu saldırıya karşı da yapıldı. Bütün haklara yöneltilmiş saldırılara karşı yapıldı aslında. Ve onlar mesleki ve siyasi olarak hak savunmanlığını, halkın avukatlığının varlığını korudular, güçlendirdiler. Bugün elbette fiziken Ebru abla aramızda değil ama korumak için canını verdiği halkın avukatlığı geleneği onun can suyuyla büyüyor. Defterinde Nazım Hikmet'ten yaptığı bir alıntıyı bulduk. Şöyle not etmiş. İnsanın ülkesinde unutulmaması ne kadar önemlidir bir bilsen, hem de ölüm yakınken. Bugün bütün dünyada unutulmayarak onurlandırılıyor Ebru. Biz de onu her zaman onurla, cesaretle ve sevgiyle hatırlayacağız. Ben konuşmamı tutuklu müvekkilimiz şair Ümit İlter'in Ebru ve Aytaç için yazdığı bir şiirden 2 kıtayla bitirmek istiyorum demiştim. Sevgili Ebru, zorbalık tanrısının kızına neden inanayım adalet adına? Haksızlık saltanatının bütün sahtekarlarına yitirdim inancımı evvel zaman içinde. Sadece size inanıyorum halkın avukatları, halk olduğum için. Sevgili Aytaç, inancım tam, tanrıçasına değil, aşığına adaletin. Açlığınla savunduğun ne varsa inanıyorum. Gözlerinin aydınlattığı yarına inanıyorum. Ebru'yla sana, cümlesiyle halkın avukatlarına inanıyorum, adalet aşıklarına. Evet, ödül için tekrar teşekkür ederek konuşmamı
Well, thank you very much, Seda. You're frozen on my screen. I hope you're still there, but again, very impassioned intervention. And I'm sure it's left us humbled, as we usually are, by the bravery and dedication of lawyers in Turkey and elsewhere who are fighting for fundamental freedoms. When Ebru died, I felt that she was the victim of a heartless state, and I think everything that I know around her death is further evidence of that. So to bring this inaugural International Fair Trial Day to an end, we have published a statement with regard to the background to the day and with a series of demands which we and all of those organizations who have signed the statement, who now number over 90 international bar associations around Europe and elsewhere, and associations of judges. And I'm just going to briefly outline the demands that we make, because these are very important demands and supported by such a wide community of lawyers and judges. We hope that they will, at some level, be heard. So the list of demands includes the following: that Turkey should take the necessary legislative and other measures to ensure the independence and impartiality of the judiciary, end all practices constituting direct interference, pressure or influence with respect to judicial conduct, including those from the executive, implement the recommendations of numerous human rights oversight mechanisms, including the Human Rights Council in the UN, Universal Periodic Review, and the Venice Commission, to introduce a constitutional amendment to make the Council of Judges and Prosecutors independent of the executive, and ensure that its decisions are open to judicial review. To amend the relevant articles of the Turkish Penal Code and the Law number 3713 on prevention of terrorism that are found to be broad, vague, arbitrarily applied against critical voices, to meet the requirements of clarity and foreseeability and the principles of legal certainty and no punishment without law. To immediately end the systematic abuse, detention and prosecution of lawyers, judges, other legal professionals, journalists, human rights defenders, opposition politicians, academics and others where there is no cogent evidence of specific criminal misconduct presented in proceedings that comply with international fair trial standards. To guarantee and respect the principle of presumption of innocence in all criminal investigations and prosecutions. To stop any practices preventing enjoyment of the rights protected under international human rights treaties, such as freedom of expression, association, and peaceful assembly, including by way of using the exercise of such freedoms as grounds for arbitrary prosecutions and lengthy and punitive pretrial detention. To ensure that the rights to fair trial embodied in Article 6 of the European Convention of Human Rights and Article 14 of the International Covenant on Civil and Political Rights are respected in all criminal prosecutions in Turkey's criminal courts at all levels. To repeal state of emergency amendments passed into permanent law, which amendments seek to enable the dismissal of judges and prosecutors without a fair hearing, and which seek to limit the rights of lawyers to discharge their professional duties, the rights of suspects to legal counsel, and the right of lawyer-client communications, as well as to impose other limitations on the justice system, as outlined in the report of Human Rights Watch, published in April 2019. To end the practice of mass trials of lawyers, judges, journalists, opposition politicians, human rights defenders, and others, in particular on bogus charges, such as the charge of membership in a terrorist organization, aimed at preventing their legitimate activities and silencing them. And finally, to create an open dialogue with the international oversight mechanisms and national and international NGOs to address and resolve the structural human rights issues in the country. And as a first step, as we've heard earlier on, to promptly agree to requests by the UN Special Rapporteur on judges and lawyers and other special procedures to conduct country visits to Turkey. And we open those demands to the international community. And we ask them also to respond effectively to the deteriorating state of human rights and rule of law in Turkey, to increase their efforts to effectively address these issues with international stakeholders for increased awareness and attention. So those are our demands, and we will continue to pursue them relentlessly across Europe and beyond, in memory of Ebru, in memory of all those who have paid the ultimate sacrifice for standing up for fair trial rights. Thank you very much, everybody.